Hello, my name is Connor McGee, and today we will be talking about assisted suicide and how that relates back to Canadian law. So first, the table of contents. The things that we'll be covering in this presentation will be definitions, background, criminal code, and how that relates back to Canadian law. We will be looking at a case study, the discussion questions, and finally the bibliography. So for some background, assisted suicide is obviously a very controversial topic throughout the world, and it is currently a practice that is deemed illegal in Canada. So before we delve into the presentation, it's important to understand some definitions. A lot of these definitions are interchangeable and a lot of them can be confused, but it's very important to understand the distinction. So euthanasia is the deliberate act undertaken by one person with the intention of ending the life of another person in order to relieve that person's suffering. Assisted suicide is the act of intentionally killing oneself with the assistance of another person who provides the knowledge, means, or both. Voluntary euthanasia occurs when the act is done in accordance with the wishes of a competent individual or with a valid advance directive. Non-voluntary euthanasia occurs when the act is done without knowledge of the wishes of a competent individual or with respect to an incompetent individual. And involuntary euthanasia, which is indistinguishable from murder or manslaughter, occurs when the act is done against the wishes of a competent individual or a valid advance directive. So next we'll look at the criminal code and how it relates to euthanasia. So section 14 of the code states this, says no person is entitled to consent to have death inflicted on him, and such consent does not affect the criminal responsibility of any person by whom death may be inflicted on the person by whom consent is given. So basically that just means like a doctor who, say, euthanizes someone could be held criminally liable. And the criminal code and aiding suicide. So under section 2.14 of the criminal code, it is an offense to counsel or to aid suicide, although suicide itself is obviously no longer an offense. So it's obviously a very serious thing that we're dealing with here. And section 241 also says everyone who counsels a person to commit suicide or aids or abets a person to commit suicide, whether suicide ensues or not, is guilty of an indictable offense and liable to imprisonment for a term not exceeding 14 years. So obviously there's a very heavy penalty for people that find themselves in that situation who are aiding someone who may be suicidal. So to kind of relate it back to our lecture notes and the things we've talked about in this course, the right to refuse medical treatment is obviously a big topic for people who do not want to continue with medical treatment. So the common law recognizes the right of an adult, competent person to refuse medical treatment or to demand that treatment, once begun, be withdrawn or discontinued. And this has to be distinguished from assisted suicide because it's not really that, though some people could say that a person who maybe has cancer doesn't want to continue chemotherapy anymore for reasons of their own, maybe committing suicide by just giving up. But obviously that's another topic of discussion that's of great debate. So next we'll look at the advantages that have been posed as far as euthanasia goes. So current proponents for the legalization of euthanasia and assisted suicide list a number of justifications, including the following. So concerns for the personal autonomy and freedom of choice of individuals, limitations in the effectiveness of palliative care in alleviating the pain and suffering of all individuals, the argument that the law violates Section 15 of the Canadian Charter of Rights and Freedoms because able-bodied people may commit suicide, but those with physical limitations cannot. Recognition that assisted suicide takes place despite its illegality and is occurring without adequate controls, and the argument that the distinction between withholding or withdrawing treatment, such which are accepted practices, and assisted suicide does not stand up to scrutiny as there is really no moral significance to the distinction between acts and omissions, as I said before with the right to refuse medical treatment. So here's some disadvantages that have been posed as well. So in contrast, those who are against such legislation often raise the following arguments. So basically the fundamental social value for like the respect of life, that it should be maintained and that killing someone is intrinsically wrong. And that legalization could result in abuses, particularly with respect to vulnerable members of society, such as maybe those with depression. So individuals might, in some cases, seek assisted suicide due to insufficient financial and institutional resources. And there's an argument known as the slippery slope argument, which allows competent people to access assisted suicide. Assisted suicide could lead to changes in the law with respect to incompetent persons. So people under the age of 18 or those who are unable to make decisions for themselves for reasons such as mental illness. Legislation to permit euthanasia could limit development to improve care for those who are dying, and advocating euthanasia would be quicker and easier than putting someone in palliative care. So, kind of medical opinion on this topic. In Canada, only 20% of doctors would participate in euthanasia if it was legal in our country. 42% would refuse, and 23% would be unsure what to do if they were in such a situation. 59% of physicians have withheld life-sustaining treatment following a patient's request. So they've actually listened to the patient's requests when they have said that they do not want to continue treatment. So 1 in 6 physicians have received a request within a time span of 5 years to euthanize a patient, and 25% of physicians in Canada believe assisted suicide should remain illegal. And so this is a case study of a Torontonian man who's 62 years old. His name's Edward Hung, and he was a man living with ALS. And he wrote an open letter to the Canadian Supreme Court stating how it wasn't fair how some people, such as himself, didn't have the same opportunity to fly to Europe, where assisted suicide is actually legal, such as Switzerland, to explore the option if they choose to go that route. He did unfortunately pass away, and his lawyers are fighting to get his case to the Supreme Court in a right to die case. And it's his case is being used as an example to make to kind of legalize assisted suicide in our country, and it kind of brings to light the fact that people that can benefit from assisted suicide, how they are not allowed the same freedom of choice to choose that route if they want to, because obviously it still is illegal. So for the discussion questions that I would like to pose to my classmates, the first one was, if you were a medical practitioner, would your view on euthanasia be different than to what it is now? Why or why not? And for the second question is, if it is illegal to euthanize prisoners on death row in some U.S. states, why should it be illegal to euthanize people who may find assisted suicide a beneficial outcome to their situation? And so that is my presentation. Thank you for listening, and I hope you guys enjoyed it. Thank you.